Bill is now in session. Please be seated.
Good morning and welcome to the Utah Court of Appeals. This morning we have two cases on our oral argument calendar. The first one is in re A.S.G. number 20220645. If I could have counsel who are here today enter appearances for the record, please.
Alexander Marischal for the appellant mother.
Morning.
Martha Pierce, Attorney Guardian ad litem for the minor child.
Morning.
John Peterson, Assistant Attorney General for the State of Utah.
Neil Skousen, appointed counsel for the father, E.G.
Good morning to all of you. Thank you for being here today. 3 appellants is a lot. Appellees is a lot. So I suppose you figured out how to divide your time appropriately, or do you have any other discussion on that point?
I believe that Ms. Pierce and I are going to split the time, and Mr. Skousen is going to sit out unless the court has direct questions that you'd like to address him. Otherwise, we'll just split the time, 50-50.
Okay, great. Thank you.
That's correct, Your Honor.
All right, and my clock says 10 minutes, so Ms. Marischal, have you already communicated 5 minutes for rebuttal? Is that accurate?
Yes.
Okay, any other questions before we begin? All right.
All right, good morning. The court made 4 distinct errors here, 3 legal and 1 against the clear weight of the evidence. To the first one, regarding the permanent custody and guardianship, awarding permanent custody and guardianship to a parent makes no sense. All of the rights bestowed by a permanent custody and guardianship are already present for a parent, with one notable and very unintentional exception. It's not modifiable by one of the parents. Because it's not modifiable, it creates a
It's
host of
modifiable
problems.
by the guardian, right?
Yes, so by one of the parents, the parent against
Okay.
whom it's awarded.
Okay.
But this creates a host of unworkable results that we believe lead to an absurd results in the statute, and that's why we argue for the interpretation of the statute that we're arguing for here, which we recognize goes against this court's recent decision in re H.C., which is why we're asking for this court to revisit that opinion and overturn that part of that opinion.
So suppose this panel reads the statute in question and thinks that there's arguments both ways. What do we do?
So that's an ambiguous statute if we're reading both ways. And so we read the ambiguity to go against the absurd results and the constitutional infirmities that would result from the current reading.
But is that enough to get us through the stare decisis implications of that?
Yes, so under
Fire away.
Under the Eldridge factors, and I'll leave aside the well-established precedent part. It's a very new opinion, so it's not very well established in that way. But to the more substantive issues of whether this is a sound decision based on solid reasoning, the permanency statute admittedly is not well worded.
But let me pause you there
Sure.
and just talk about it systemically before we get to the statute. Even under the Eldridge factors, don't we give some deference to the fact that a prior panel decided it the other way?
Yes, of course.
Right, and so it's not just a function of us looking at it now and thinking, oh, that was wrong. I mean, I don't know the right adjective here, but we'd have to really think HC got it wrong to return it, right? Mm-hmm. And if we think it's close, HC controls. Fair?
Correct.
Okay.
Yes, so and that's why we have 3 other arguments. So that's, but we do think that the Eldridge factors weigh so heavily in the other direction that it does result in something where this court should overturn, again, that part. And it's a fairly narrow part of that decision. It's just the part that says the juvenile court has to pick one of the 3 dispositional options in the permanency statute.
And let me explore your argument that is just sort of on its face absurd. I mean, I get that it's kind of weird, different, unusual to say to a parent, hey, we're going to also, in addition to you being a parent, we're going to denominate you a guardian. Right, I get that that's a little weird, but couldn't the legislature have been thinking, well, hey, we're talking about adjudicated children here, children who have been adjudicated, abused, or neglected, typically, and so we want there to be additional restrictions on the other parent's ability to come in and modify the arrangement. Couldn't the legislature have been rationally thinking that?
It could have, and to answer that question, I'm going to zoom out pretty high level, because I think it's important to understand all of the considerations that are going into the permanency statute, which is where this language is coming from, as opposed to other parts of the statute. So here, the goal of the permanency statute is to make sure that we are moving a child along towards legal permanency. When the child is with a parent, they already have legal permanency. we don't need to provide it. That parent has all of the rights and responsibilities that the child needs a person to have. The point of a permanent custody and guardianship is to bestow a non-parent with those same rights and responsibilities. And that's laid out in the statutes. In the definitions section, there's a definition for legal custody and there's a definition for guardian. And it's just a conglomeration of those words. There's nothing magical about permanent custody and guardianship as like a whole phrase. It's really just a combination of those rights and responsibilities that we're bestowing to a non-parent. And the reason we have to do that in the permanency statute is to move that child towards that status. When the child already has that status, there's no additional protections. The only thing is the fact that it's unmodifiable by the one parent. But the divorce code and all of the custody statutes already take care of that, as well as our case law. For a parent to modify a custody award, like the normal custody award, they have to overcome the substantial change in circumstances bar. And especially if they want to flip custody, our case law says you have to not only have a change with the parent themselves, the parent that's petitioning to modify is not enough. It has to be a change in the custodial ability of the custodial parent. So it's actually quite a high bar to overcome to modify already just under regular custody statutes. So the additional protection or the additional restriction in the statute of permanent custody and guardianship doesn't actually add anything to that parent's protections. It just creates this problem where no one can petition if there is such a change, or the one parent can't petition if there's such a change. Now, the language is a little strange, even for the parent that holds the guardianship. It's not clear that that parent can really do anything either. It's just when we read the statute, what it comes out to is this is not how this is supposed to work. And the permanency statute operates without ambiguity when there's two parents, or when there's no parent versus parent context.
Not how it was supposed to work sounds like an argument best made to the legislature.
And it could be a legislative fix, but I think the wording of the statute supports a reading that would solve all the problems. And that is in the language of the statute where it doesn't specify which parent we have to return a child to. It just says the child is returning to a parent.
Well, in context though, isn't that statutory phrase, return to the minor's parent, isn't that referring to the parent with regard to whom we're making a substantial risk determination at the permanency hearing?
I think we have to read additional words to get there. I mean, it's returning from the custody of the division. So as long as it's returning from the custody of the division to a parent, there's nothing in that language that specifies that it's to the parent that the child was removed from.
It says returned to the custody of the minor's parent.
Mm-hmm. And in this case, the child was returned to the custody of the minor's parent.
But in the context, I guess I'm asking, so I guess you're disagreeing with me maybe. But that language seems embedded in, and I'm reading it from subsection 2 now, not subsection 4. It's the same basic phrase.
Mm-hmm.
And in subsection 2, it seems very much geared toward the parent with regard to whom the substantial risk determination is being made.
That's because the statute was written with the typical case of we're talking about parent versus non-parent. So we're talking, they were envisioning a world where returning to the parent is returning to the person from whom the child was removed, that they were one and the same.
And how do you know what they were envisioning?
Because the rest of the statute operates that way, and it doesn't make sense. Again, awarding that permanent custody and guardianship to a parent doesn't really make any sense.
Let me push back on that, just perhaps for sake of argument, because what I think we're about to hear from either the state or the guardian ad litem, whoever goes first, is that it does make sense for the following reason. Once you have a parent who's been adjudicated as having neglected the child or abused the child or what have you, now we're in a different world, and the legislature seems to have the purpose of trying to create permanency for the child, to take the child out of limbo, is the phrase that was used in some of the briefing. And their point is, because we're in that really particular world in which an adjudication has happened, that's why it makes sense to sort of short circuit the whole process. Why are they wrong about that? And two, why are they so wrong that we would then overturn HC on that basis?
So the fitness of the parent doesn't bear on the permanency. So, I'll explain why.
Yeah.
The fitness of the parent is about what jurisdiction the court has to intervene in the family in the first place, to do anything. Getting the child to permanency is about where the child goes. So the fact that the parent is unfit or fit or has been adjudicated, that's the reason we're in juvenile court in the first place. But it's not the reason that the permanency statute needs to apply.
Don't they have some bearing on each other, though? I mean,
Well, in the sense that that's why the parent is there.
Right.
As opposed to not being there. But it's not a reason to order something that's unnecessary or to order additional restrictions that are not needed just because that parent has been adjudicated to be unfit. The point of moving that child out of legal limbo, and again, this child is not in legal limbo. This child is with a parent. So that's just not even a consideration for this child. As soon as they are with a parent, those timelines are no longer at play because they're there.
So are you saying that 409, 83, 409 doesn't even apply in a situation like this? Because the statute starts off with, if reunification services are ordered with regard to a minor who is in the custody of the division. So
Yes.
your argument is that 409 doesn't even apply.
I think there is an argument that it doesn't apply at all. That is not the argument we relied on here, just because I think there's a more clear path that is a little less broad. I think it does apply in the sense that we do have to do something about reunification services. We have to decide whether or not those are extended. And I think that part of the statute does apply. The only part that doesn't apply is the part where the court is required to choose one of the 3 dispositional options listed in the statute. And that's because the child has been returned to the minor's parent.
Yeah, I understood your argument that subsection 4 doesn't apply.
Correct. That's right. So it's not the statute as a whole. Again, we're dealing with those other issues. We're still moving that child towards permanency, but this child, because they're with a parent, is not in that legal limbo.
Because you're not contesting the propriety of the juvenile court undergoing a substantial risk inquiry as to your client.
No,
The juvenile court had to do that
yes.
in the context of this permanency hearing.
Because that was one of the permanency goals. And that's one of the other problems in this case, is that we had 2
And so-
conflicting primary permanency goals.
Right, the statutory question then is, does the phrase "the minor's parent" in subsection 4 mean the same thing as it means in subsection 2? Because with regard to subsection 2, the minor's parent is the parent with regard to whom the substantial risk determination is being made, right?
It doesn't
because-
have to be.
Well, there was no substantial risk determination made by the
Oh,
court
I'm
here
sorry,
with
in
regard
subsection
to
2.
father.
Right, well, no, so the court still
At
has to
this
decide
permanency.
that. And the court decided that here. It just it's a little bit more implicit because the father wasn't in the hot seat, so to speak. So the court still decided that the child should go back to the custody of her father.
I saw nothing in the record indicating that this court was ever asked to make a substantial risk determination with regard to father, because the child was already placed with father, had been
So-
placed with father since the shelter hearing.
Yeah, it made that determination at that point. When it placed with father, that was when that determination was made, so it essentially was made earlier.
Right, so when we're talking about what the court did at this shelter here, at this permanency
Mm-hmm.
hearing, the court's dealing with a substantial risk determination with regard to your client only.
So it's almost as if that's already stipulated, because the court has already decided that there's no substantial risk of placing with father here. Because they already did place with father, so it's as if that's already
But it's a different
been done.
statutory, at the shelter hearing, it's a different statute, governing statute, right?
Yeah, it's a
Because
different- yes.
reunification services haven't been provided at that point, so the
No.
court makes a determination at the shelter hearing, I'm gonna place with father, but the court doesn't have to go through at that point.
Well, no reunification services were ordered as to father. So the statute, that's probably the better answer. The statute doesn't apply to him because he doesn't fall into the category of if reunification services are ordered.
Well, isn't what you just said sort of fatal to your statutory argument, right? The parent at issue here is the one to whom reunification services were offered, right?
No, because the dispositional options are about where the child is, not about whether the parent had reunification services ordered. So it's, as long as the child is back with a parent, then the court is free to use other options. And it doesn't have to stick to the strict permanency listed options that we're dealing with in that statute. And it's more of a systemic problem where that's a specific problem we're trying to solve. It's more to your question, we're trying to solve the question of what do we do with a child when we have parents that can't take custody back? But here we do. So we don't have to deal with that problem here. And it then becomes just, what do we do going forward? Which is what what the juvenile court was dealing with here. And ordering a permanent custody and guardianship doesn't give the parent, the now newly custodial parent, additional protections or anything special. It gives them exactly what they already have. The only thing is it messes up the district court's jurisdiction so that the district court can't modify anything if the non-custodial parent can, even if they can prove a substantial change in circumstances. It kind of makes them forever unfit, which is not really what this is supposed to do. I mean, the juvenile court's jurisdiction ends. The court could, or the non-custodial parent could cure their problems, could fix those issues. And that's exactly what we want to leave open in these cases. And a permanent custody and guardianship is intended to do that with respect to a non-relative or a non-parent, like a relative or another individual. It's intended to leave the possibility of the parent coming back into the picture open
Well,
so that we
your-
keep those connections
Your
together.
client is entitled to reasonable parent time, right?
Yes,
And your client could go back in and litigate that,
yes, and has.
and
And-
has in this case.
Yes. Yeah, that's definitely, and that's part of what the juvenile court actually sent over to the district court is the reasonable parent time, because the juvenile court didn't make that determination. So it's almost like it's sending part of the analysis back, but not the entire thing. It's not giving full jurisdiction back to the district court to be able to make those determinations about custody going forward. So it does create a problem that is best solved by reading the statute narrowly. As long as the child is with a parent, then we don't need to strictly adhere. It actually gives the juvenile court more power, more deference to fashion the appropriate remedy in the situation instead of being boxed into these remedies that are really intended for non-relative or non-parent placements. So, I'll move on to the other legal, oh, I'm sorry, so I'm out of time, so I'll save those for later. Thank you.
Okay, thank you.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. We gotta read the statute in the context of all of Title 80. The juvenile court is bound by Title 80. And to say this is not a typical case ignores 80-3-302, which says when a child is removed, before you ever consider foster care, you first have to consider the other parent, and then you consider a relative. So it's contemplated that this is a typical case where the court did what it was supposed to do. It first considered the other parent. And 83-302 says that when you place with the other parent or a relative, it says you still have to have your 12-month permanency hearing. So if you read those two statutes in harmony, then 409 absolutely applies when a child is with another parent. And to say that that child has permanency, even though the case is open and the child could bounce back and forth, is totally disrespectful to the child's point of view. Because bouncing back and forth is, I mean, that's one reason Title 30 has a higher standard for modification.
Isn't it
because-
at least a little bit curious, just as a matter of language, if not a matter of law, to refer to dad as the guardian of the child, given that he's the natural parent?
It is, but at this point, his rights are limited because he's under juvenile court jurisdiction.
Okay.
So,
But even so, I mean, this is one of the points, it's not obviously all of their point, but one of the points that Ms. Marichal has made in briefing in an argument today is that it's just odd to refer to a natural parent as a guardian.
I give you that.
And if it is so odd, then that might suggest that your proposed reading is not the reading that the legislature really intended. And if they've given us a reading that gets around that oddity, why don't we go there? Because I understand that to be one of the arguments they're making. This just doesn't make any sense language-wise.
Because if you're looking at the weight of either side of the argument, one is that it's really odd to call a dad a guardian. But I think that's what's contemplated under 83-302, that we're gonna look to foster care as our last choice. We're gonna go to non-custodial non-custodial relative, that. So just because it is kind of odd and awkward, that's one of them. But on the
What's the legal effect then of giving him a guardianship?
of giving father guardianship,
Yeah.
then he has full custody, he has guardianship, and he has that protection against having to go back to court to litigate a modification.
Let me ask it a different way. What additional rights does he get by being called guardian that he didn't already have as natural parent?
Well, he's gone through juvenile court, which means the child has had their status adjudicated. And at this point, while the juvenile court has jurisdiction, the constitutionally protected parental presumption on both sides, they no longer have that because of the adjudication. Now, under In Re KF, it says the parental presumption is restored when custody is restored. But what it really means is full unfettered custody. When you just have custody with juvenile court jurisdiction, that's not really custody because the court can change it at any point. So his parental presumption and his constitutional has been restored. Mother's has not. She remains presumptively unfit because she has
So
not.
calling him guardian does what?
Well, under the whole structure of the juvenile court, calling him guardian, which is awkward, gives him custody, gives him guardianship, restores the parental presumption, and protects that child from having to ping pong back and forth.
Do you agree with Ms. Marischal that father was not ordered to undergo any reunification services?
As I recall, initially he was not the target of reunification services, but he was subjected to orders of the juvenile court. He submitted himself to the jurisdiction, so.
Well, there was a dependency finding as to him, right?
Right.
But the child was placed with him at the shelter hearing, so I think she's right that no reunification services were
Right.
necessary or ordered with regard to him since the child was unified with him at that point.
Exactly. But sometimes, but under 83-302, it says you can order services to the parent from whom the child was removed or the parent to whom the child went, or both. So the court could have, if it felt like father needed that extra boost, but he didn't.
But they wouldn't then be reunification services as such because the child's already with him.
No, they
It'd
wouldn't call it
just be
reunification.
services.
Exactly. And I've seen cases like that too, where you have two permanency goals. One is remain home, one is return home, because it's two different parents. And that's concurrent planning, and that's best practices, actually.
And can I ask you a question? It's a little bit afield of what we've been talking about, but your time is at the 2-minute mark, so I'm going to take you there. One of the things that you've argued that the state, I don't think, embraced quite as fully is that there's something of an invited error problem from
Exactly.
Mother's side. Let me just ask an initial question. Are you asserting this as waiver/invited error, or are you asserting this more along the lines of lack of preservation/forfeiture?
I'm not sure. Invited error is when you make an affirmative statement
Right.
that the court does have all these powers that she's now saying the court does not have.
And that's what you think this is, right?
That's what I think that's what I
Okay.
think that memo did.
Okay, so you said that in your red brief, and then in response in the reply brief on page 2, they point to a place in the record in which the mother actually asks the juvenile court to simply grant custody to father and then transfer the case back for further proceedings. And is she right about that that's what mother said?
She did, I believe she did ask for simple custody, but that's very different than saying the court has no jurisdiction to do what it did. Because her memo certainly does say the court had all these powers that she's now claiming the court does not have. So I think she's stopped from making any jurisdictional argument that the court does not have power to do what it did and to read the statute the way that she did. When she argued for simple custody, she was just saying, Your Honor, you have two choices here. She didn't say you're legally stopped from doing this choice over here. She said you have two choices. And her memo certainly acknowledged that the court did have that power.
Okay.
If there's no other questions, I'll thank you for your time.
Thank you, Ms. Pierce.
May it please the court, John Peterson on behalf of the state of Utah. I'd just like to start out saying it seems to be an undercurrent, which I think the A.S.G court recognized too, is that Section 409 is maybe not a perfect fit for all the circumstances we find ourselves in. Section 409 clearly contemplates nuclear family versus the state kind of a situation, and I think towards the end of A.S.G, this court recognized that the solutions provided by the legislature are maybe imperfect to some extent. I think the permanent custody and guardianship statute was primarily intended to deal with something like a relative or something to kind of insulate that person from further litigation with a parent. However, I would not agree, with the appellant that it's ludicrous or improperly applied in a case like this. I mean, there are clearly circumstances, as this case demonstrates, where insulating a parent from future litigation and providing some greater degree of permanency is a salutary goal. I mean, you have a parent who's made 22 referrals who simply ceases to accept, that the father did not sexually abuse their child. And I mean, the court recognized this is a situation that needs to end. This child needs some permanency. This child needs to be not subjected to rape exams in the future investigations. And whereas the father stands before the court, I mean,
But why does there need to be a permanent guardianship to ensure that? Why couldn't the divorce court itself enter orders to that effect?
I mean, the divorce court could, but, I mean, as this court recognized in H.C., I mean, essentially H.C. Foreclosed that alternative. I mean, this court clearly said, that there is not an option to shunt the case off to the district court. That the court needs to resolve and provide permanency. And so, I mean, that's where we are with H.C.
Well, I mean, which is why they've led with an argument that HC should be overturned. One of the things that's come up in that context is how enshrined the HC rule is. And both your brief and the guardian litem's brief give us cases from past decades in which permanent guardianship orders have been entered against a parent. And their response in the reply brief is that while those cases involved those kinds of orders, that they weren't aware of a case in which that issue had been litigated until HC came along. Are they right about that?
I think they are. I mean, it's been happening for decades, but it's been recently, I would think, in the last 2 years, it's kind of come to a head, and there's been some attempt to kind of address whether or not permanent custody and guardianship really is an appropriate remedy. And
Okay, so if we don't have an appellate case that squarely confronted the legality of that practice, are they right that the principle has not really been enshrined in the way that we normally think about enshrinement for stare decisis purposes?
I mean, yeah, I mean, you mean that enshrined is, there's a opinion saying, yes, this is the way we interpret the statute and from 20 years ago or something. No, I don't believe that does exist in the case law. It is relatively recent in that respect.
Okay.
I mean, however, many of the other, tenets of stare decisis do still come into play. I mean, you don't want to come before this court every few months and ping pong this back and forth. And, I think everybody kind of recognizes that this really is an area where there could be some tweaking to the statute. But, as I argued in my brief, that really is a policy decision, probably better left to the legislature to look at the interplay between the district courts and the juvenile court a little more. I mean, it seems that in recent years, the juvenile court is becoming a little bit more of a mini divorce court. And it seems like we're getting an upswing in these cases that kind of devolve into parent versus parent rather than parent versus state cases. Which is not exactly what the juvenile court was intended to do, strictly speaking.
In the context of determining whether to overrule HC, what, if anything, should we make of the fact that the Supreme Court denied cert in that case?
I mean, I think it signals that the Supreme Court felt the case did not, need addressing, and that that this court had probably interpreted the case, at least in accordance with the statute, as best it can be. Whether, Section 409 is not necessarily a perfect statute. I mean, no statute is a perfect statute. But, as this court recognizes, that the legislature essentially created 3 options for the juvenile court to apply, and it had to choose one or the other. I mean, here we are at permanency. What are you going to do to serve permanency as a child? Choose one of these things that we've been provided by the legislature, and if you don't like them, go back to the legislature and ask for some more alternatives. I think I essentially have addressed what I intended to address, and if the court has further questions. Thank you for your time.
Thank you, Mr. Peterson. Back to you, Ms. Marshall.
All right. Going to jump around a little bit. So I think the state just highlighted one of the absurdities here, and that is that we're limiting the juvenile court to these 3 dispositional options when we don't need to. And that is part of the absurdity here. We're limiting that court's power to fashion the appropriate remedies to those 3 narrow options when it's really not necessary, and as the state stated, is probably not the intended result, since that's not really the way the statute was written. To get more into the nitty-gritty of your question about the wording from subsection 2 versus subsection 4, they are worded slightly differently, though I see where the same phrase is used. But in subsection 2, we have that the return of the minor to the minor's parent would create a substantial risk of detriment to the minor's physical or emotional well-being. The minor may not be returned to the custody of the minor's parent. And then down in subsection 4, we have if a minor is not returned to the minor's parent or guardian, we add the word guardian there, at the permanency hearing, the juvenile court shall, unless time for reunification services is extended, do the following things. And that's the subsection that we really have a problem with. And I think there's enough difference between those 2 subsections that we can read.
Other than or guardian, what differences do you mean?
So the minor may not be returned to the custody if there's a substantial risk. So there we have the word may, so it's a little bit more of a discretionary word, as opposed to what we have in subsection 4, that if a minor is not returned to the minor's parent or guardian at the permanency hearing, the juvenile court shall. So it's a much more strict subsection and mandates something much more narrow.
Yeah, the question in my mind is the 3-word phrase, the minor's parent.
And I think that's where they
Give me your
included
best
themselves.
argument as to why it means something different in subsection 4 as it means in subsection 2.
It doesn't mean anything different. It's just in subsection 2, because that subsection is applying where reunification services are ordered, the parent that has custody just isn't part of that subsection.
So the phrase, the minor's parent in subsection 2, you agree that means your client? And
Because-
not, and
because-
not dad?
Right, because we're talking about reunification services being ordered.
So generally, when we have similar language in the same statute, just different subsections, and the legislature's just sort of copied and pasted that language down into a different subsection, there's a fair inference, isn't there, that that phrase means the same thing later?
Normally, I think yes. In this case, I think it creates an ambiguity because of the structure of the statute and the way that this is intended to
I
operate.
mean, it just seems, if I'm the legislature and I'm trying to write the statute to get to the outcome that you're positing, it feels like when you get to 4, what it would really say is, if a minor is not returned to a parent or guardian of the minor, like adding the article A, the letter A, would get us where you want us to go. But because it's still using the minor parent or guardian, and it's the that seems to link up to 2.
So this is a little bit what my analysis of the use of singular versus plural. The same thing happens with child. We obviously mean child to mean, in
Children.
statute, can mean multiple children. The minor's parent, I mean, it's the minor's parent. It's the is going to the minor, I guess is the best way to put that. We're talking about that. Whether it's a or the, I think certainly in like normal parlance would be more clear. But I don't think that that's significant in terms of what the legislature was intending. And again, if we zoom out to the point of this statute, I think that's where we get to. And this court has, in a footnote in JH, talked about this difference between when we're with a parent versus not. And in that footnote, it was footnote 5 of JH, which is 2006 Utah App 205, where the child is instead placed with a non-custodial parent, the child's return to the other parent may be less urgent because either outcome may further the goal of preserving the family. That's talking about the permanency statute. So we have that goal already achieved here with the father, which is why we don't need to apply this very narrow, very strict dispositional outcome in this case. And to clarify, we're not arguing the court didn't have jurisdiction. That's way overstating our argument here, and which is why this is not an invited error problem. The court clearly has jurisdiction over this family. So there's not a jurisdictional problem. What we're saying is that doing that leads to an absurd result that gives nothing. And to your question, the definition of guardian in the juvenile code in section 102 under subsection 35 is a person appointed by the court to make decisions regarding a minor, including the authority to consent to marriage, enlistment in armed forces, major medical decisions, and legal custody. A parent has all of those things. They don't need to be a guardian. Legal custody is the same thing. That's subsection 50. It's defined as the right of physical custody, duty to protect, duty to provide the minor with food, right to determine with whom the minor shall live, and the right to authorize emergency surgeries. A parent has all of those rights already. They don't need to be given those things. Now, this dad needed to be given legal custody. That's true, because he didn't previously had that. But that is all he needed to be given. So he didn't need to be given this additional layer that creates a problem where the district court can now no longer go in and modify as needed with the much more fine-tuned tool of Title 30, which has lots of factors. The court can fashion longer-ranging remedies and make a better decision for this family going forward, and instead of limiting us to this very sort of awkward tool that was never intended to be used that way. There's no other
You're at
questions.
zeros. I'm wondering if you can give us your best, minute, I don't want to put a number on it, response on the invited error issue. You just alluded to it there, but obviously I asked Ms. Pierce about that. Why do you not have an invited error problem?
Because mother asked for the exact same result that we're asking for here, that the juvenile court just enter a simple legal custody, and then certify the issue to the district court where there's already a pending divorce action to deal with the details of how that custody plays out in the future. That's exactly how it's intended to work. That happens all the time. I mean, if we're talking about enshrining this principle, juvenile courts have done that pretty regularly as well, probably about as regularly as they order permanent custody and guardianship. So it's, to that extent, it's not an invited error. That's exactly what mother asked for. We didn't say that the court didn't have jurisdiction. That would have been maybe an invited error, but that's not our argument on appeal, so,
Okay, that's helpful, thank you.
thank you.
Okay, thank you. We appreciate the arguments that have been made this morning. We'll take this case under advisement and issue a decision as soon as we're able to do so. Our next case is scheduled for 10:15, and in the world in which we stream our arguments live, we like to make a habit of not starting early. So we're going to take about an 8-minute break and be back in at about 10:15. Thank you.
All rise.
Oh, I should say, drive it now.
This court is now in recess until 10:15.
I should have gone.